any evidence to corroborate those admissions, the case should be dismissed. And it's very clear, we both cited to the same exact case. That was the Sheriff v. Dada case. And the law is very clear that we cannot have just the confessions, because if you just leave that to the jury is going to just assume guilt because he confessed. And so without the state providing any evidence outside of those confessions, that's a huge problem. It amounts to a legal trial, a trial that won't have the correct result. And so the state is saying that basically we were, we should have done this as a habeas petition. I disagree with that. Here's the reason why. We are not contesting probable cause. What we're contesting is, after all of the evidence has been delivered, there's no corroborating evidence. There's nothing. And then the state also stated that we're just looking for a corpus delicti, you just have to look at the body. If there's a body, there's corpus delicti. And that's just not the rule, Your Honor. There has to be, obviously in this case, a body, but the state has also alleged that this was assisted, promoted by a gang. And so those facts have to be evident. And the only way we have those facts is from Mr. Davis's own mouth. The other participants in this, which I'll talk about in my second argument, are all dead. And so, but for Mr. Davis speaking and giving those statements, there is no corpus delicti in this case. I'll go to argument 2. And that's Mr. Davis's right to a fair trial and due process. The state pointed out the correct standard of review for that, and I don't disagree with that standard. However, the part that we disagree with is whether Mr. Davis is prejudiced or not. They're saying, well, the witnesses that died are going to give speculative, well, it's speculative as to what the witnesses would say. In those cases, yes, that would have been the situation. In this case, it's different. I'll just concentrate on these 4 witnesses, Your Honor. Eric Martin, and just for the court's edification, Eric Martin was the person that supposedly gave the gun. DeAndre Smith, he was in the backseat. Terrence Brown, he was the driver, and Orlando Anderson was alleged to be the actual shooter. Without these 4 co-conspirators being alive, being available at trial, basically Mr. Davis is completely prejudiced from proceeding. And his defense is he made this all up for profit. These individuals, these co-conspirators, have to exist in an effort to kill Mr. Tupac Shakur. If they're not alive, if Eric didn't give him the gun, if DeAndre wasn't the driver, if Orlando didn't shoot, we don't have a murder according to the state's theory, which is following, again, solely the admissions. So we go back to when was this information available to the state? I would allege that it was available all the way in 1996. Everybody knew Orlando Anderson was in a fight with Tupac. Well, he wasn't in a fight, he got beat up by Tupac and other members of his gang viciously. He was the #1 suspect right off the bat. There should have been an alert. The police should have been searching for Orlando Anderson, but we always knew where he was because he went back to LA. They could have been in contact with him. They could have gotten statements from him. They could have gotten statements from Mr. Davis. They could have gotten statements from Mr. Martin. They knew all of these players way back in 1996. I don't know what happened. I'm sure Mr. Giacomo doesn't know what happened in regards to why the district attorney's office did not proceed with prosecution or at least an investigation at that time. But it's a tactical delay that goes severely against my client because now all of these players are dead. I'll fast forward all the way to 2009. In 2009, the Metro officer comes down to LA and gives us, Mr. Davis gives the statement. That statement, all of the elements of this murder and what the state will attempt to prove at trial if the trial goes forward, is what Mr. Davis had said. They had that information. They did no investigation. At that time, Eric Martin was still alive, and also Terrence Brown was still alive. Orlando had passed in 1999, and I think DeAndre Smith in 2005. But at least two major players in this co-conspiracy are passed. The DA's office, again, does not do any investigation beyond that. And so, with that, we feel that my client's sufficiently prejudiced beyond repair. It leads me back to the immunity argument. In 2009, I counted, well, I'll just go through the pages, Your Honor. In that 2009 discussion with the Las Vegas Metro Police Department's officer, Detective Long, on page 3, he says, no intent of arresting Keefe. Page 11, I'm not here to arrest you. I'm not here to arrest you. I'm not going to arrest you. Page 12, you're free to leave. I'm not going to arrest you. You can go wherever you want. Page 103 and number 4, Terrence Brown was still alive, and the detective said, I was not going to arrest him. Page 134, I want to close the Tupac case. Page 138, this is confidential and covered, and you cannot be charged on it. Basically, you have the state was given the information by the LAPD. The LAPD had a immunity agreement with him out of the 2008 confession. The 2009 confession came by a product of Detective Dupree. Detective Dupree set that up. The only reason he set that up and why my client would have agreed to was that everybody was on the same page, that immunity was going to be provided. If it wasn't, how come he wasn't arrested right then and there? Because he said, I got the gun from Zip Martin, we were in a white Cadillac, I handed it to the back seat, and then Orlando took the gun and shot Tupac. All of that information is back there in 2009, but again, the DA office, and again, it's not these players, it's not Mr. Wolfson or Mr. Giacomo. That decision was made back then not to proceed with the trial. And now it's the state's burden, we believe, to show why they did not go forward and prosecute. They just can't sit here and say, well, he kept talking about it. No, you had that information in the beginning. You should have arrested him back in 2009. And so it had to be for a tactical advantage. That being, everybody's dead. It leaves Mr. Davis on the hook, and then he can't answer for all of the statements he made after that, other than it was for profit. And so,
regarding the timeline that you've laid out,
yes, Your Honor.
would Mr. Martin and Mr. Brown have been alive after the Compton Street Legend book was published, or no?
What is that, 2018, right?
2019, no. Terrence Brown dies, I believe, in 2015, and Zip Martin, I don't recall exactly when he died.
But it's not your argument that he ultimately would, if that's the state's triggering event for starting to investigate, that he would not have been alive at that time. Is that accurate?
After the book, right, when the book was published.
Yeah.
But after the 2009, he was still alive.
Of course, the Detective Long interview, of course, they're
Right.
still alive, but except for Mr. Anderson and Mr. Smith. Okay. I just wanted to make sure I had made it.
Yep. And outside of any other questions, Your Honor, we submit.
Okay, thank you, Mr. Arnold. Mr. Giacomo, anything you want to add?
Just briefly, as it relates first to corpus delicti, that's death by criminal agency. Obviously, Mr. Shakur didn't shoot himself, so that is satisfied in a homicide by proof of the facts and circumstances, which were testified to, by the way, at the grand jury. And it is an argument. We didn't go through all of the evidence that is potentially out there. Their argument is there was insufficient evidence presented at the grand jury in order for them to be held under the corpus delicti rule. Even if you were to take it a next step further and say you have to have